So, after Trump's second travel ban by executive order, a judge strikes it down again, suspends it. I'm very skeptical of the constitutional precedent that this suspension has. I want to see if there's actually any constitutional basis for shutting down this order. So I'll just preface this by saying we're going to be talking exclusively about constitutionality here. We're not going to be talking about negative impacts of the executive order. We're not going to be talking about how it has different effects than intended, how the intention is not based in reality. That has no bearing on the constitutionality of it. Trump could ban immigrants from Mars, and it would be constitutional. Because even though there's no real reason for him to do it, the intention behind such an order is not based in reality. It's like an imagined problem of Martian immigrants. It doesn't matter. We're talking about constitutionality here. And we're trying to see if this executive order actually undermines the Constitution or contradicts it. So let's see what we can get into here. So it starts off by defining, reiterating exactly what the executive order does. And then plaintiff's motion for temporary restraining order of the executive order, that is, shutting the order down, or at least temporarily. So Dr. Elshikh alleges injuries on behalf of himself, his family, and members of his mosque. Well, have pity on his mosque. So far reading this seems to be the meat. The main argument had here seems to be about this statement. Plaintiffs allege that the executive order subjects portions of the state's population, including Dr. Elshikh and his family, to discrimination in violation of both the Constitution and the INA, denying them their right, among other things, to associate with family members overseas on the basis of their religion and national origin. How this contradicts the Constitution is beyond me. Just think about the effects of taking this logic to the extreme. Let's say that any citizen, so Dr. Elshikh, I'm assuming, is a citizen here. Any citizen has the right to associate with their family members, even if those family members are foreigners. Let's just take that. Is that actually true? To take it a step further, where does the right to associate with other people originate? It originates in the First Amendment, which says that the people have the right to free assembly, or, associate with whomever they choose to. Let's just say that that language then entitles any U.S. citizen to associate with any foreigner, and in extension, it entitles that foreigner to come to the U.S. in the case that the U.S. citizen wishes to assemble with that foreigner. Just think about the impacts that would have on society. Literally every foreigner that exists on the planet would then have the right to come to the United States if they can find some U.S. citizen that's willing to speak on their behalf and ask the foreigner to come here. This just baffles me. And this is just the logical extension. This is a more restricted domain. It's saying any U.S. citizen has the right to assemble with their foreigner families. Now, this might just be my opinion, but I think the First Amendment or the Bill of Rights in general only guarantees rights to citizens, and that includes the citizens who are appealed to by the freedom of assembly. The right to free assembly only guarantees assembly between citizen to citizen relationships. And even then, it does not guarantee citizens a space within which to assemble. It does not guarantee them some meeting hall or anything like that. And it really baffles me, like they seem to tie this into religious discrimination just as like an afterthought to maybe make this seem actually a bit more tied with the Constitution. I can tell what they're trying to appeal to. They're trying to appeal to the First Amendment, freedom of assembly. But, you know, what this has to do with religion is it just doesn't make any sense. Like, the only thing I can see that springing from is that the travel ban only applies to Muslim majority countries. But even then, it doesn't discriminate against Muslims expressly. It discriminates on national origin. They're actually right about that one. But let's just talk about religious discrimination of countries with a certain majority religion. Well, like let's say Trump made a travel ban on Israel, citing like Jewish terrorism. Many Jews don't even live in Israel. This is not a connection between church and state just because the country has a majority religion. In fact, when Trump talks about the justification for his executive order, sometimes he talks about radical Islamic terror, but he always mentions the terror aspect. He always mentions banning these countries which are threatening our security. He's not talking about banning them because they're Muslim. There are so many more Muslim majority countries that are not included in this ban. So many more. We're not even including the majority of Muslims within this ban. So this claim that the executive order has anything to do with religious discrimination is very strange to me, very peculiar. The state purports that the executive order has injured its institutions' economy and sovereign interest in maintaining separation between church and state. Again, I went over how does this injure separation between church and state. Because let's go into religious discrimination even further. The religious discrimination clause of the First Amendment protects U.S. citizens' right to practice their religion within the U.S. Well, what part of this order usurps that ability? Even if you're talking about how U.S. citizens are not allowed to associate with their family members of the same religion, how does that restrict their ability to still practice their religion? And even say this travel ban literally said, we will ban all people who practice the Muslim faith from entering the U.S. That is, ban any non-citizen who practices Islam from entering the country. So just any person that the state claims follows Islam, any foreigner that is. Say we did that, you would still not be able to appeal to religious discrimination. Because religious discrimination is just a protection of the U.S. citizens' right to practice any religion that they want. The ability to practice a religion does not hinge upon the ability to associate with foreigners. If you really need to associate with a foreigner, leave the country. Just go travel to them. or have a Skype call. I mean, I mean that's kind of a first world answer, but what are you going to do? This is just how the Constitution is. Okay, and this is a funny part. This gets back to my preface that we're just going to be talking about things that put this order's constitutionality in jeopardy. According to plaintiffs, the executive order also results in their having to live in a country and in a state where there is the perception that the government has established a disfavored religion. The perception being the key word here. What part of the Constitution restricts the government's right to have a position on religion? I mean, there's a precedent for the government to maintain a secular position on things. But maintaining like a Christian outlook or stigmatizing a certain religion is not restricted by the Constitution. They're fully within their rights to stigmatize the religion because it doesn't abridge anyone's rights and it's not expressly forbidden in the Constitution. So I'm just kind of baffled and annoyed that in a document that I would expect to only have to read about things pertaining to the unconstitutionality of the ban, to have to read something like this, which has nothing to do with constitutionality. Is anyone actually claiming that the Constitution prohibits the government from establishing a perception of a favored religion over a disfavored religion? No. And think about this. Think about like Scientology. Would you be mad if the government came out against Scientology? Just came out with that position. They didn't do anything. Like they didn't like discriminate against Scientologists. They just said we don't like Scientologists or something like that. How is this something that we're even mildly worried about? Plaintiffs assert that by singling out nationals from the 6 predominantly Muslim countries, the executive order causes harm by stigmatizing not only immigrants and refugees, but also Muslim citizens of the U.S. Right. So, the unconstitutionality of the executive order apparently now depends on what stigmas it causes. Plaintiffs point to public statements made by the president and his advisors regarding the implementation of a Muslim ban, which plaintiffs contend is the tacit and illegitimate motivation underlying the executive order. The funny thing about the Constitution is it doesn't say anything about the motivation behind laws. The president is not restricted from making an executive order under a specific motivation. If the motivation is illegitimate, that factors in 0 to how unconstitutional the executive order is. And I'm just mad that I have to read this when I came here expecting legitimate reasons why this order should be overturned or temporarily restrained. Okay, and then the plaintiffs make like a bunch of statements here, which again just points to how it's an illegitimate motivation and it stigmatizes Muslims. It has nothing to do with this. No, it's not the Muslim ban, but it's countries that have tremendous terror. It's countries that people are going to come in and cause us tremendous problems. It doesn't matter if you agree or disagree that these countries have tremendous terror. It doesn't matter that his justification for the order is illegitimate. even if he was justifying this executive order by expressly saying we should keep America un-Islamic, we should keep more Muslims from getting into the US, it would still not be unconstitutional. It would just be unseemly. I would denounce it with all my heart, but it would still not be unconstitutional because we're just talking about justifications right now. We're talking about motivations for the order. Since when have motivations been a factor in the legality of an order or a law? President Trump said he was establishing a new vetting measure to keep radical Islamic terrorists out of the US, and that we don't want them here. Wow. He wants to keep radical Islamic terrorists out. Such discrimination. How dare he? How dare he not be accepting of radical Islamists? I just love this. He said, once again falsely, as if that has any bearing on the arguments. A lot of the criticisms against Trump seem to be about what he suggests rather than what he actually does. And this is a prime example. We're seeing constant references to what Trump has said he wants to do and what he intends to do and what motivations he says he has. And yet, we're seeing this executive order that is not in any way unconstitutional, despite what Trump might have said about his justification for it and whatnot. It's just, actions speak louder than words is a good principle to go by when you are judging politicians. Because politicians can say anything, but they can't usually just do anything they want and get away with it. Because what they do is more telling than anything about what they will actually do in the future. Plaintiffs argue that in light of these similar statements, where the president himself has repeatedly and publicly espoused improper motivation for his actions, the president's action must be invalidated. It's the judicial branch's duty to interpret the law, not to determine whether the law is good, and then from that say, oh, we should invalidate it. This action has improper motive. We don't want to enforce this. But it's not your job. Your job is to interpret. And in some circumstances, particularly regarding constitutionality, you're allowed to countermand these actions when they're unconstitutional. The judicial branch is not concerned with the ends, the intended ends of the law. They're only concerned, in the case of constitutionality, they're concerned with the means of the law. And in most cases, they're just concerned with interpreting the law and enforcing the law. It's not your job to legislate. It's not your job to look at the law and say, I don't want to enforce this. This looks unjust, even though it's not, because it's not unconstitutional. Citizenship is an unlikely indicator of terrorism threats against the US. So, and very few individuals from the 7 countries included in the executive, this is the past executive order, the one before that was overturned, had carried out or attempted to carry out terrorism activities. You even admit that there exists some individuals from the 7 countries. But it still doesn't matter. It has nothing to do with your argument. Either you put forth an argument that the law is unconstitutional, that the executive order is unconstitutional, or you shut up and enforce it. This is not your jurisdiction. You are not the legislators. Okay, here's where we actually get down to brass tacks and say exactly where in the Constitution we're finding these violations. So, plaintiffs assert the following causes of action. 1. Violation of the Establishment Clause of the First Amendment. 2. Violation of the equal protection guarantees of the Fifth Amendment's Due Process Clause on the basis of religion, national origin, nationality, or alienage. Number 3, violation of the Due Process Clause of the Fifth Amendment based on substantive due process rights. 4, violation of the procedural due process guarantees of the Fifth Amendment. 5, violation of the INA due to discrimination on the basis of nationality and exceeding the President's authority under Section 1182F and 1185A. 6, substantially burdening the exercise of religion in violation of the Religious Freedom Restoration Act. 7, substantive violation of the Administrative Procedure Act through violations of the Constitution, INA, and RFRA. And 8, procedural violation of the APA. Okay. So let's actually see where they argue how these are unlawful, how these are making these violations. So we have 8 USC, so 8 the US Code 1185A. Unless otherwise ordered by the President. Well, funny. I seem to remember a case where the President has ordered, where the President has made an order. So it seems that this clause, which is referred to in here, in this little statement, it says that Sections 2 and 6 of the executive order exceed the President's authority under 1185, U.S. Code 1185A, which says, it shall be unlawful for any alien to depart from, or enter, or attempt to depart from, or enter the United States, except under such reasonable rules, regulations, and orders, and subject to such limitations and exceptions as the President may prescribe. So right there, right on the tin, you see any alien is prohibited from entering the country unless the President prescribes certain rules and regulations that allow them to enter. So we actually see the U.S. Code is sanctioning the President's travel ban. It's not even contradicting his ban. It's actually advocating for it. It's showing support. I don't see how in any way the President is exceeding his authority when it comes to this section. It seems pretty simple. The President is allowed to, through his own reasoning, let certain people enter the U.S. and keep other people out. very arbitrary. But this is the law. This is U.S. code. And somehow this is usurping the reasonable bounds of the president's authority. Unless otherwise ordered by the president, these things shall be unlawful. The president is otherwise ordering that it shall be unlawful. So, not only is the default that it should be unlawful, but the president is expressly making it unlawful. So, this is double plus ungood for the illegal aliens here. Okay, and then the judge's statement also refers to U.S. Code 1182, Section F. Suspension of entry or imposition of restrictions by president. So it's just baffling to me, cause I've actually read this section before, and this is the main reason why I'm baffled by these claims that Trump's travel ban is unconstitutional. Is we're seeing an instance in actual U.S. code that appears to completely sanction Trump's travel ban.
Whenever the president
finds that the entry of any aliens, of any class of aliens into the United States
into the United States, if it would be detrimental
of the United States,
to the interests of the United States,
and for such period as he shall deem necessary,
by proclamation,
suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants,
suspend the entry of all aliens
of aliens,
or any class of
restrictions
aliens
he may
as
deem
immigrants or non-immigrants, or impose on the entry of aliens any restriction he may deem to be appropriate.
So he may by proclamation. Well, it seems that he is by proclamation doing something. He is by proclamation, by executive order, he is launching this act into action. And then it says, whenever the president finds that the entry of aliens would be detrimental to the interests. Well, we have seen in this statement by the Hawaii judge here, well, at least the plaintiffs were arguing that indeed the entry of these aliens is not detrimental to the interests. It says whenever the president finds this. So this is totally subjective. Not to mention that the president might even have information that you don't. It's totally under his reasoning and his only that this applies. He can ban any alien or any class of aliens from entering the U.S. regardless of whether you think that it would not be detrimental to the interests. It's whether he finds it detrimental. Now, if the president found that this class of aliens were not detrimental to the interests of the United States, then that would be a bit weird. But we wouldn't actually, we're not mind readers. We can't read the mind of Trump. We can't actually know if he actually thinks that the entry of people from Iraq, Iran, whatever, would be detrimental to the interests of the United States. And so, after reading this, we go back here and we say, what does this statement, what do the plaintiffs say about these little sections? They say that the executive order exceeds his authority. Exceeds? These two sections seem to directly sanction the president's travel ban. This seemed to sanction this executive order, the legality of it. These two sections seem to set that precedent, and I don't see in any way how this is exceeding the authority of those two sections of U.S. code. The plaintiffs are asserting that the executive order infringes on the due process rights of numerous U.S. citizens and institutions by barring the entry of non-citizens with whom they have close relationships. So the plaintiffs actually think that the entry of non-citizens should be allowed if they have close relationships with citizens in the U.S. Just unconditionally. And what does this have to do with due process? This argument has nothing to do with trying to discern, say, whether the non-citizens are truly non-citizens or not. It just seems to be such a random word to put there. Why is this term here? This has nothing to do with due process. What you're talking about here is some made-up right that U.S. citizens have about being able to see their family members who are non-citizens. So apparently the plaintiffs demonstrated standing. So this is pretty standard. Yep, so they're just talking about the financial losses of the executive order and non-monetary losses, damage of collaborative exchange of ideas. The funny thing about this is you could make this claim all the time. Any state could always make the claim that their university is suffering damage to their collaborative exchange of ideas from the United States not having completely open borders with every country. Because to an extent, we restrict immigration from every country on Earth. There's no country where unconditionally we just give people the ability to come to our country. But of course, this is just kind of a side note. We're talking about standing. Yes, Elshikh has standing. Yes. What are? Well, let's actually just see what he's talking about here. He's probably talking about his mosque and how people can't come to his mosque. He's an imam. His wife is of Syrian descent. His mother-in-law is a Syrian national. So now his mother-in-law can't visit him, which of course is not unconstitutional. It's not a right guaranteed by the Constitution. He is deeply saddened by the message that both executive orders convey. Who cares? Yes, ripeness. Alright, so here we go. Legal standard for the temporary restraining order. So now the court, it's actually the court that's talking about the merits. Everything before this was about the plaintiffs who were talking about their justification for the temporary restraining order. Here we're seeing the court is trying to see how likely it is that there is actually a violation of the Constitution here by the executive order. Because a reasonable, objective observer would conclude that the executive order was issued with a purpose to disfavor a particular religion, in spite of its stated religiously neutral purpose. I'll grant them this. This is a true statement. It is likely that a reasonable observer would see that the purpose of this executive order is to disfavor a particular religion. I mean, I would argue against it, but whatever. What does the purpose of the executive order have anything to do with the lawfulness of the order? The lawfulness of the order pertains to the means by which it accomplishes its goals, and it's also pertains to whether the effects of the law are unjust. Unjust in the sense that they infringe upon rights guaranteed in the Constitution, or just in any law, really. I could propose that I want to eat an ice cream cone because I want to get skinny. My purpose for eating an ice cream is that I want to get skinny. It doesn't matter what purpose I said the act of eating the ice cream is. The means by which I eat the ice cream cone, that is, I lick it and I sink my teeth into the ice cream, that would be the logical analog in this little metaphor. And then the ends of the eating the ice cream cone, that it will have the effect of making me fatter. I could propose to eat the ice cream cone because I want to go to Mars. Eating an ice cream cone has nothing to do with whether I will end up on Mars or not. You can just see how useless the purpose of my intended act is. It doesn't matter if the executive order was issued with a specific intent. The intent to disfavor a particular religion. That does not reflect well on the government, that it seems to be taking non-secular stances, but there's nothing prohibiting the government from taking non-secular stances. There's only parts of the Constitution which prohibit the government from making laws that disfavor a particular religion, infringe on religious freedom. Having a purpose in mind does not inherently disfavor the religion by law. It does not abridge religious freedom. It's just a purpose. It's just words. You're just saying, I want to do this thing because of this. Well, it doesn't matter what you say in the because of this clause. What really matters when you're talking about lawfulness is what's on the inside, what's actually in the order. I would not be happy if this was the reason that it succeeded, just because of the purpose of it. You need to look at the actual content, not just what you think Trump meant by doing this. So they're going to talk about the Establishment Clause, that the government cannot favor one religion over another in terms of laws. They can't make a law that discriminates against a certain religion. Now, I know I just talked about how the purpose does not factor in here. But it says, according to this case, government action 1 must have a primary secular purpose. Well, who defines what the primary purpose is? That just seems like a very subjective claim. It's very hard to weigh one purpose over another. So let's say there's like maybe two justifications for the travel ban. One, that terrorism in the selected countries is at disproportionate levels, thereby posing a national security threat, and maybe another purpose which would be Islam is bad or something like that. So one of them is a secular purpose, and the other is a purpose which favors all religions above Islam or disfavors Islam. Let's say that you determined there were these two purposes behind the travel ban, which I think you could agree that there is some argument to be made about there is at least some disproportionate element of terrorism in at least some of the countries that are affected by the travel ban. You can see how there at least exists the purpose that is secular, that is, there is terrorism. not all of the purposes, the conceivable purposes behind this order are actually non-secular. And so who determines, how can you weigh one of these purposes between the others? I would argue that this is only up to the person who created the order. That is, Trump decides what the primary purpose was. If he says it was a secular purpose, then the primary purpose is secular. Maybe I'm just completely wrong here, but which purpose is actually the primary purpose, to me, seems like a very subjective thing. And I suppose that's the whole point of a court system, is that you're arguing about subjective things, and you just have to come to some conclusion about those subjective notions. But I still stand by my idea that it doesn't matter what the primary purpose of the government action is. Two may not have the principal effect of advancing or inhibiting religion. Again, I have to say, who decides what the principal effect is? So let's say we have one effect of the travel ban is that it restricts the access of terrorists into our country, and the other one is that it restricts access of Muslims into our country. So one of those has the principal effect of advancing or inhibiting a religion, that is the one about Muslims, and the other one doesn't have anything to do with religion. How do you weigh which one is the principal effect? This seems very arbitrary. There is no metric by which you weigh these. These all seem like very abstract ideas that you could just interpret them any way to get what you want here. 3, may not foster excessive entanglement with religion. I'm just going to say, if you really get down to this executive order, all it's doing is banning immigration from 6 Muslim-majority countries. It's banning from countries. How is that excessive entanglement with religion? Purpose.
Again. Say
purpose.
Again. I dare you. I double dare you, motherfucker. Say
purpose.
one more goddamn time.
Okay, here, it's actually defining the executive order's primary purpose, which somehow the court is able to determine which one is the primary one. It is undisputed that the executive order does not facially discriminate for or against any particular religion, or for or against religion versus non-religion. I would think this would be enough to just kick this case out. Oh, this is interesting. So actually, this executive order, unlike its predecessor, does not contain any term or phrase that can reasonably be characterized as having a religious origin or connotation. I didn't actually know that that was a change of this executive order. That's pretty good. At least there was an effort to get to some sort of more secular nature here. So this is interesting. By its reading, the executive order could not have been religiously motivated because the 6 countries represent only a small fraction of the world's 50 Muslim-majority nations and are home to less than 5% of the global Muslim population. This is what I keep talking about. The suspension covers every national of these countries, including millions of non-Muslim individuals. Well, that seems pretty secular. The illogic of the government's contentions is palpable. What is illogical about these statements? They seem pretty valid. So the notion that one can demonstrate animus towards any group of people only by targeting all of them at once is fundamentally flawed. Why is that fundamentally flawed? Let's say we have a situation where there's a cafeteria which is serving desserts, and it has donuts and it has ice cream. Let's say the cafeteria decides to temporarily suspend serving chocolate ice cream or something, but it still has other flavors of ice cream. How can you say that we are then demonstrating animus towards ice cream as a whole? How can you say that cafeteria is actually displaying distaste for ice cream as a whole by removing chocolate ice cream? We're seeing a very comparable situation here, because look, we're targeting specific Muslim majority countries. The specific chocolate flavored ice cream, we're banning that because we think that type of ice cream in particular is dangerous. We're saying that this chocolate ice cream has a disproportionate amount of terrorism in it. The cafeteria has decided to stop serving this chocolate ice cream because we found there's a disproportionate amount of carcinogens in the chocolate ice cream. We don't want to give our customers cancer, so we're going to remove this. So you can see, like, how is this? This is not fundamentally flawed logic. This logic totally works. I mean, in certain circumstances, I could definitely see how this would be flawed logic, but it's not fundamentally flawed. You have to look at the context surrounding it. The court declines to relegate its Establishment Clause analysis to a purely mathematical exercise. This is why sometimes SJWs are just not taken seriously at all. Like, you can find instances of Trump insulting specific women, and some SJWs will use that as justification for saying, hey, Trump is sexist or misogynistic, without any regard for the context. And you can see in the context, Trump is clearly insulting the individual, not the group of women entirely. He usually doesn't base his insults, on these arbitrary characteristics of whether it's a woman or a Muslim or whatever. It doesn't matter how many women Trump insults. You have to look at the context behind them to see if he's actually insulting the woman because she's a woman. And it's the same case here. You can't just say, oh, because he's targeting specific Muslim majority countries, that means he's insulting Muslims as a whole. This is just fundamentally flawed. You have to look at the context surrounding this. You can't just look at how all of the countries in the ban are Muslim majority. So I'm curious to see at what extent would this court find a travel ban on a specific country to not be targeting a specific religion. Think about it. Any country, you pick any country on earth, there will always be a specific majority religion. There's always a religion that is practiced in that country more than others. So what if we banned, like Germany? What if we banned people from traveling from Germany? The majority religion there, I think, is Catholic, if I'm not mistaken. Would this court then conclude that Trump is discriminating against Catholics? So, how far do you have to go? Like, they're making this argument, we should not be looking at the mathematics behind this. We refuse to do so because we're talking about this establishment clause. Well, how far are you willing to go? Where's the cutoff? If if the country is 50% Muslim, is it still discrimination against Muslim? If it's, if it's 30%, is it still discrimination against Muslims? 30% still being the majority, assuming there's like 20% of Catholics and 20% of Hindus and whatnot. To what extent do you apply this logic? Because it seems as though you could apply the Establishment Clause to very many different cases with just the same valid logic of not wanting to reduce this to a mathematical exercise, which I don't claim that it is a mathematical exercise. It's not like Trump picked the top 6 countries for proportion of Muslims. I mean, he even says, like, the way that these countries were selected was by some law in Obama's term. Yes, I agree that the context in which a policy arose is quite important. As I've demonstrated, I want them to look at the greater context of this case, and they don't seem to be. See, here we actually have a quote from Trump where he's actually talking about how it's not a Muslim ban. I don't think it's a rollback. In fact, you could say it's an expansion. I'm looking now at territories. Territories in particular. People were so upset when I used the word Muslim. Oh, you can't use the word Muslim. Remember this. I'm okay with that because I'm talking about territory instead of Muslim. Yeah, I mean, Trump said, he's calling for a shutdown of Muslims entering the country. I'm okay with using this as long as you are also providing some other contextual evidence for how the executive order is discriminating based on Muslims. Well, so far I've only seen that the court has argued that the purpose behind the executive order violates the Establishment Clause, not that the actual content of the order or like the effects that it has is a violation of the First Amendment. How does the purpose of the executive order contribute to the harm that it espouses? Again, like if I propose to eat an ice cream with the purpose of getting skinnier, it doesn't matter if I say that I want to get skinnier. The irreparable harm that eating the ice cream has is that it makes me fatter. My stated purpose has no bearing on what irreparable harm in particular the action has. So in this case, you have the executive order where all the court has talked about is just how the purpose behind the order is in violation of the Establishment Clause. They haven't actually shown how the implementation of it violates the Establishment Clause. And so I don't see how they can just presume irreparable harm as a result of that. Oh, there's irreparable harm done to Dr. Elshikh because the perception of the government is no longer secular. That is not irreparable harm. The loss of First Amendment freedoms. See, I don't think the First Amendment freedom guarantees that the government keep up a perception or a stigma of being secular. I don't think freedoms are infringed by what the government thinks. The government may be committing a thought crime here, but that thought crime is not causing harm to Dr. Elshikh. So now we're at the conclusion. So yeah, basically they just temporarily overturned the executive order on the basis that the perceived primary purpose of the executive order was religious. And this is just awful. how this has anything to do with constitutionality of the executive order is just completely beyond me. Maybe I'm missing something. I don't think the Constitution guarantees that the government keep an entirely secular face. If they accidentally come off as favoring one religion over the other, should we really be that concerned? Again, we should be completely, in this discussion, we should focus completely on the legality of the content of the executive order. We should be focused on what's inside it, not what is intended by the order. What is intended by the order is irrelevant. It doesn't matter whether I intended to get skinnier by eating the ice cream. The lawfulness of this action is only determined by the means and the ends, not by the intentions, not by the intended ends, and not by the intended means, purely by the implementation and by the outcomes.